This hearing is in the matter of case number CFI 070-2018 before Justice Lord Angus Glennie. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Al-Tamimi and Company. Lead counsel is Mr. Sharif Shivji QC, assisted by Mr. Hussein Sharifi. The defendant is not present.
Thank you very much.
Thank you.
Yes, Mr. Shivji.
Good morning, Your Lordship. We've filed a skeleton argument. I hope that's managed to reach Your Lordship.
Yes, it has. Thank you.
I'm grateful. Probably just like Your Lordship, we only just learned a moment ago that Mr. Al-Hashimi wasn't joining the hearing today.
Yes.
And I don't want to recap the detail of our skeleton, in which is a lot of information, but Your Lordship will recall that at the last hearing on the 6th of July, Mr. Al-Hashimi was given extra time to comply with the order as his request. And Your Lordship had an exchange with him about the fact that you'd given him extra time, and that should really give him plenty of time to do the things that the court had ordered him to do. And at that hearing, you also said to Mr. Al-Hashimi that in the event that he was unable to comply with the order, he would have to set out his position clearly and precisely in an affidavit.
Yeah.
And Mr. Al-Hashimi accepted that. Since that hearing, we have heard nothing from Mr. Al-Hashimi until the 10th of August, which was the date that Your Lordship set for compliance, where he emailed the registry minutes before the deadline was due to hit, asking for the details so that he could make an application for an extension. And the registry provided that information very swiftly within minutes. In the event no application was made, but we assumed that this hearing would be contested. And again, we had nothing further from Mr. Al-Hashimi until the email exchange this morning, where he seems to have told the registry that he's not proposing to attend. In terms of taking Your Lordship through the application, perhaps I'll take Your Lordship through the potted highlights.
But we can take it more quickly than that, can't we? Because the order that was made required compliance with quite a lot of disclosure obligations and information obligations. There was a provision in the order indicating the lines of the order that might be made in default of compliance, although not ruling anything out. And we're now in the position where there has not been compliance. There's been no explanation of why not. And I suppose take it on that basis. Really, it's a question of looking at your order, isn't it?
Well, I'm grateful, my lord. And
where is the draft?
The draft is in the R section of the bundle at tab 12.
Yeah.
Now, in relation to the other defendants, on the 22nd of March, Your Lordship effectively made the same order as against those defendants. So what we're looking to do in this order is simply replicate what Your Lordship has already done against the other defendants. And we would say the position is, in fact, exactly the same. It's essentially the same group of disclosure obligations that they've not complied with, the same history where they've asked for, well, where they've essentially had their head in the sand and not engaged with these proceedings. And then the court has been forced to deal with this at a hearing where they haven't turned up. Does Your Lordship have that draft order available?
Yes. If we can just go through it, maybe.
I'm grateful. So the first paragraph deals with the sanction.
Well, I think the recitals, I think it's important to have a recital that Mr. Al-Hashimi, that the third defendant has not appeared at this hearing, and that I'd like to have it recited as well that on 10th of August, he indicated that he might apply for an extension of time, but no such application was made. Shalom, are you there? Well, who's there from the registry? It's important that the registry can make a note of the points I'm making. Shalma?
I think the registry have actually just dropped. Looking at the attendees for this hearing, I think the registry have just fallen off. They've just rejoined. Yeah.
Hello, can you hear me?
Yes, I think.
Apologies for that, Your Honor. I was disconnecting for some reason. I am here, I'm available, and I'm taking notes.
Thank you. I just wanted to make sure that you are following the changes we're making. We're basing ourselves on the draft order at tab 12 of section R of the e-bundle. Yep.
Yes, Your Honor.
And I think what I want to do is in the recitals, recite two things. First of all, that on the 10th of August, Mr. Al-Hashimi for the third defendant indicated that he would be applying for an extension of time to comply, but that no such application was in fact made. Yeah?
Yes, Your Honor.
And secondly, just record that there was no appearance for the third defendant at this hearing today. Mr. Al-Hashimi having notified the registry, I think it is, by email that he did not intend to appear.
Yes, Your Honor.
Now, where do we go from here? The defence of the third defendant struck out. Is that where you're going to come to next? You're muted. Mr. Shivji, you're muted.
I'm so sorry. It's just finishing off those points on the recital. The final recital just deals with attendance. And obviously, that would only record my attendance on the basis that Mr. Al-Hashimi has declined to attend. Yep. And perhaps I could just ask the registry, when they record Mr. Al-Hashimi's non-attendance, I think perhaps it would be worth just reciting that he was aware of the hearing and has notified the registry that he has decided not to attend.
Yeah, I just said that he had sent by email to the registry saying he didn't intend to appear. Yeah.
I'm grateful, my lord. So then turning to the body of the order, the first paragraph deals with the sanction for non-compliance with your previous unless order. And that's the same sanction that we applied for the other defendants, and we say it's appropriate because the documents sought go to the heart of the defence being advanced.
Yeah.
The second paragraph deals with judgment in respect of our debt claims. And I've previously addressed your lordship on the fact that there are other claims. They may not add much, and certainly for present purposes, it's the debt claim that is the bulk of the loss. It's very straightforward. It's been outstanding for some time. Again, that's the same order that we sought against the other defendants, and all we've done is updated the contractual interest figure so that it is current as of today's date. The third paragraph deals with the date for payment of the judgment in accordance with the usual rules. And the fourth paragraph deals with interest on judgment debts pursuant to the judgment rate under the practice direction. The fifth paragraph deals with the other claims which we want adjourned with liberty to restore. And
is that what we've done with the other defendants?
That's what we've done with the other defendants. And my clients will have to take a view on what they do with those and whether it's in fact economic to pursue them any further. And then the sixth and seventh paragraphs deal with the question of costs.
Yes.
You on those points.
Yeah. Would you want to address me on the question of costs?
I'll be grateful. Perhaps I'll deal with the seventh paragraph first. So this, again, mirrors the position that we took in relation to the other defendants. The logic of the position is this. Up to July 2020, we had commenced proceedings, obtained a default judgment, and then on the application of the defendants, they obtained permission to set aside that default judgment, albeit that the judge in doing so noted that the threshold for doing so was very low. It was at that point that effectively...
What order did the judge make about costs on that occasion?
I'll find that. If you give me a moment, my lord, my junior will find that reference for you, and we'll have a look at it together. But that July 2020 reference is a reference to the fact that it was at that point that default judgment was set aside.
Yeah.
And it was at that point the defendants essentially went live with their defence, and the essence of their defence was that they hadn't entered these facility arrangements with my client. In fact, the documents were forged, and this was an elaborate fraud perpetrated on them by their own employees. Now, we say that that defence was fictitious, dishonest, and the document production that we sought throughout has gone to that, and the defendants have never been able to produce the documents to substantiate that defence. So we say that...
Can you show me where the third defendant's defence is to that effect?
Yes. So the third defendant's, all of the defendants, all of the active defendants, so this is the first, third to eighth defendants, filed one single defence, and that can be found in the bundle at A tab 3.
Yeah.
So that's one common defence, and if your lordship pulls that up, page 26, there's a summary, and that explains the position of all of the defendants.
Page 26, yeah.
And in particular, paragraph 7.
Yeah. Can you just go back to the beginning of that defence? It says this is the 7 defendants' reply. There are 8 defendants listed.
That's right. So the second defendant, in fact, it says, if you look at the head note, it says not used. And that claim was discontinued, albeit on certain provisos. So they've never been an for present purposes, they've never been an active defendant in this litigation.
Yeah. All right.
So
And what order did I make about expenses against the other defendants?
To exactly the same. So this mirrors paragraph 7 of my draft order, mirrors what we had said in relation, what your lordship had ordered in relation to the other defendants. And as I explained, the logic of it is that essentially they went live at the end of July 2020 with this, we say, fictitious defence. They've never managed to substantiate it. And essentially that has caused the last 2 years worth of litigation. And we say that we should never have been put to that expense in circumstances where they couldn't substantiate the defence that they were advancing. And that's a fortiori in circumstances where they were pleading fraud. Now, admittedly, they weren't pleading fraud against us. They were pleading fraud against their own employees. But we would say the same high standards apply to where a party pleads fraud. You should only do it if you've got proper evidence, prima facie evidence, and they've never managed to produce anything. We say that would substantiate the idea that this transaction was perpetrated by a fraud on them.
Yeah.
So that is paragraph 7. Does your lordship want me to deal with that in any further detail? Or is
Not at the moment. I'll consider both 6 and 7 together.
I'm grateful.
What's next? What's 6 about?
And then so six deals with really primarily us being here today. So 6 is intended to deal with the position since your last order on the 7th, on the 6th, at the hearing the 6th of July, which was made into an order on the 7th of July. And your lordship will recall that at that hearing, my clients wanted this application to proceed on a more expedited basis. We wanted the matter to come back before the court before the end of term.
Yeah.
It was Mr. Al-Hashimi who said he wanted more time for compliance. He explained his funding difficulties in terms of lawyers, but notwithstanding those difficulties, your lordship explained that it was appropriate to make the order, and that if he was unable to comply, he should file an affidavit providing his reasons for non-compliance. Critically, Mr. Al-Hashimi accepted that. There was no suggestion from him that he wouldn't do that even if these funding difficulties continued. He appeared to understand that that was an obligation that fell on the third defendant, simply as a litigant, as an active defendant in these proceedings.
Yes.
And it was on that collective basis that your lordship gave him the extra time. He doesn't seem to have used that time wisely. The purpose of the order was to get documents out of him. The vast majority of those documents are in the power, possession and control of the third defendant. So it was a matter of handing them over. I recognise that some of them would have required some collation, but some of the categories were identified categories that Mr. Al-Hashimi had previously separately identified in his evidence to this court, and it ought not have been onerous to hand them over, but he has wholly failed to do so. And
But
also
he simply hasn't responded further since the 7th July order. That's really
he hasn't, exactly. And perhaps this is a convenient moment to look at that email that he sent to the registry on the 10th of August.
Let's see it,
which is found in the bundle at R tab 7.
The tab 7, yeah. Yeah.
And in that, he said, DELMA Engineering intends to apply for a short extension of time for 10 days to comply with the order because we were not able to finalise the instruction to the new legal representative.
Yeah.
Now, the impression that one gets from that is that it's 10 days to comply, not 10 days to come up with an explanation as to why you can't comply. And also, your lordship will note that was the 10th of August. And if he had been given 10 days, that would have taken us to the 20th of August, which has already passed. So the impression one gets at that point is that they are going to comply, but they haven't been able to finalise, and I emphasise that word, their instruction to the new legal representative. The registry that came back gave him the login details to make that application.
Yeah.
It was never made. And then we are to the email exchanges this morning. And those email exchanges came about, I don't need to go into huge amounts of detail, but we noticed just a minor error in the transcript from the last hearing. We raised that with the registry, asked for it to be corrected. The registry rightly said that they should ask Mr. Al-Hashimi for his opinion on that part of the transcript before they corrected it. And it was that email to Mr. Al-Hashimi that seems to have prompted this exchange. And we say that Mr. Al-Hashimi's email from this morning is very unsatisfactory. So he says he's requested support from the company partner, that seems to be the Al-Marakis, we understand, to cover the cost with no feedback received. And the same for my request for advocate support from the DIFC. I didn't receive any feedback, which didn't let me prepare the reply application. Since the company is incapable of incurring such costs, I request the Abu Dhabi court for allowing me to step down from the case as custodian. Now, we've not been getting any details of when all of this has happened. He presents it in a way to suggest that these steps have already been taken, but no detail as to the dates. And what's been happening in the meantime is that we have been busily preparing for a fully contested application with all the bells and whistles that the defendants have put into previous hearings, including issues of UAE criminal law and civil law. Only at the last minute for Mr. Al-Hashimi to pull out. And this is, we say, unreasonable behaviour. It has put us to additional costs because we've been preparing for this hearing, not knowing what defence would be advanced, but knowing that the high likelihood is it wouldn't be accepted. And that just makes it more expensive to litigate. And this is not the first time this has happened. This is now the 5th hearing of this unless order application. 4 of those have been in relation to DELMA Engineering. DELMA Engineering has not filed a skeleton argument for any of these active hearings with no explanation as to what their position is. They haven't replied to correspondence.
I have your point.
I'm grateful.
How much are you asking for by way of immediate assessment? Because you've submitted 2 statements of costs.
I believe we've submitted one statement of costs, which is at R tab 19.
I thought you'd submitted a second one yesterday. Well,
I think that was the. I think that is the statement of cost that's relevant for this hearing. So, in accordance with the rules, we served it 24 hours before the hearing, and that's at R19.
Where you're seeking 114,600.
That's correct. Dirhams, that's right.
Yep. That's about £25,000.
I think it might be a bit more than that, but
30,000. Yeah.
And that's in the same ballpark as previous hearings. It's a little bit more, but I mean it's just a factor of the work that's put in. One of the challenges with this case is that although some of the points have been in play previously, as one moves on in the litigation, as different things happen, additional work needs to be done. The skeleton argument, in fact, doesn't really rehash what has happened before. It contains quite a lot of new material that we thought was relevant to this hearing. We've also prepared in this hearing for potential arguments again about the UAE criminal investigation. We'd also given consideration.
Nothing more about that.
We haven't heard any more about that. I mean, one of the difficulties with fighting a blank wall is that one never knows. And with the greatest respect, the defendants have a track record of raising points either the night before the hearing or at the hearing for the first time. And so we did think, because we wanted this hearing to be hopefully final and conclusive, we have prepared for what we thought were the likely things that they might say. And that obviously adds to the cost as well. Now we've obviously been reasonable in our preparation. We haven't hasn't got out of hand. We haven't prepared things that were silly or unnecessary, but we've taken the reasonable precautions so that today would be a useful hearing. So we didn't have to then ask your lordship for an adjournment if something that seemed like it might be raised was raised. Yeah. So that explains the cost, and we say that they are, we think, fairly modest for the amount of work and effort that's been put in.
Very well. In paragraph 6 of the order, so I'll just bring up the order again. Paragraph 6 of the order, I will insert figure of AED 114,615.86. And then paragraph 7 of the order, I will introduce by the words except as otherwise dealt with. There's nothing else to do, is there?
There's nothing else to do. I said to your lordship I was going to come back on the costs of the set-aside application, and
oh yes,
your lordship, would your lordship just kindly give me a moment? Just, I don't understand that's in the bundle, so I'm just getting that.
It doesn't matter, because if I introduce 7 by except as otherwise dealt with, then any costs order made on a set-aside application fall outside paragraph 7.
Yes, agreed.
Okay. So, Sharma, have you got all those various detailed changes?
Yes, Your Honor.
Thank you very much. Is there anything else, Mr. Shifty?
Nothing. Sorry, can I just check my emails to see if I've had anything from my team? Actually, no, but my junior actually just clarified that order anyway. So the defendants were ordered to pay the claimants its cost of the application on the indemnity basis.
Right.
And I think that was there were some reasons offered by the judge for that order, but effectively. He said an appropriate way, in my view, to sanction the defendant's default is to order the claimant its cost of this application on an indemnity basis. So the judge obviously wasn't happy with the defendant's conduct and thought that was the appropriate order. But as you say, the order that you have provided for in 7 addresses that.
Yep. Very well. Well, I'll make an order in those terms, and there's no purpose in having any written reasons attached, because if it comes to a challenge, your skeleton arguments and your witness statements cover the position.
That's correct, and your lordship kindly confirmed that you've considered those points. I'm grateful.
Yeah.
My lord, as you know, some of these claims have been adjourned with liberty to restore. We will reflect on the position. I don't at the moment anticipate we will need to come back to you, but if we do, we might write, if there is something that comes up, given your lordship's history with this matter and understanding of the detail, we might ask that it comes back before you. But again, that will be a matter for you and the registry to decide on.
It matters for you to ask the registry, and we'll see what take it from there. Thank you very much. Shorter hearing than sometimes, and thank you for your assistance. That concludes the hearing.
Sorry, I just had another email from my solicitors. Let me just read this if you don't mind. Yeah, no, I think that's everything. I don't think there's anything else.
Yeah. Well, thank you very much. That concludes this hearing. Thank you.
Okay, many thanks. Okay, bye.